This meeting is being recorded.
Oh, goodness.
Okay, so Kate Floss, influenza, fighting for the Commonwealth. I'm fighting from, and then I've got my Oreo team. Kate's called Kate Floss and the Oreo team, and we're all fighting for the Commonwealth. And then, as you know, that we put in for Jacinda Ardern, we've called several ministers to the court using the 1688 Will and Mary, the ancient laws, the common law, and what we're setting out to prove is that we can call a minister, we can as an individual with no lawyer, if we have a question of a point of law that's repugnant to our 1688 Will and Mary that belongs to the Commonwealth of England, Ireland, Wales, Scotland, Australia and New Zealand, let's be reminded that America and Canada are not under the same laws. What Brent's messaging, can you keep an eye out there for me, Sharon, please? Just answer him for me. Do all the answer for me. You be the secretary. What we're trying to do is to bring them into the court over some of these things that they're doing. We know that they are determined to bring down the Commonwealth, to remove our ancient common laws and protections, our constitutional laws, and stop us from getting declarations from the court. And many people have entered the court. They've been blocked from going to the court. Two of the ways that they block people from the court is, number one, under a law called the Manic Law that says if you want to take, they're saying that the government is a corporation, and if you want to take them to court, a corporation is not a person, therefore it must be represented by a solicitor. So they've said you as an individual can't take them to the court. And then the other one is, but I got past that. I managed to get past, I wasn't supposed to get past, but I did. Are you muted? Can you unmute, Jody?
Yeah, I'm fine. I was
All
just
right,
coughing.
Oh, right. Okay. So anyway, we did manage to get through, and then we've appealed it. I've appealed it, and I better speak from the aisle so I'll get anybody in trouble. I appealed it, and then when I got to the appeal under the Declaratory Judgment Act, so I got to the appeal, and they've hit me with $10,000 in fees. All right. Now the first fee was $1,000. So I'm going to go and show you the fees here. And what's the battle at the moment? The battle at the moment is to get past these fees and not have to pay them using we only use our 1688 Will and Mary and nothing else. What's Brent saying is messaging. I can't see him. I can't deal with him. Right. So I'm going to go to the share screen and I'll show you the list of fees. Now, I did pay $500 to enter the court, which I shouldn't have paid, and I passed the court process, and we'll have to do another video to show the court process, okay? And I passed the court process, but when I actually got into case management with the Crown Counsel, and the judge was there, Justice Cook J, and the Crown Counsel refused to send the ministers to the court. They said, you're not worthy of coming to the court. And they said, we're not bringing anybody to see you. So you can just, and then they hit me with a $2,700 court fee. Now I've negotiated with them and they've said to me, I can pay $300 a month, which I can manage. And, but if I win in the appeal, then I get in any money that I've paid back, and I don't have to pay it. But I don't think that's suitable. What I'm trying to fix for all of you is that you never have to, when you go using the Declaratory Judgment Act, that you never ever have to worry about the court fees, that it's just going to be smooth sailing. So I'm doing the fighting for you. We're doing it. If you're on YouTube, you can't see my my Zoom meeting, but I think that the Zoom meeting is down the bottom on the thing there, and I think that you can join it if you want to, or you can just sit there and listen. So I've got quite a bit to get through to you today, so I'm going to go to I will actually put up here, just for those people that want to Oh, now where's it gone? Oh, that one's out. All right. So if there's anybody that wants to donate to me, you would never be able to donate enough money to me to cover all the court fees. But if you do want to donate to me to let me buy some chocolate or go and buy myself something, here is the, oh, you can't see it on YouTube, but I'll be posting this later. So here you can see here on Kate Floss, donate, ASB New Zealand, Miss CM Waterman, 12316701011350. Now, the money doesn't go to any court fees and it doesn't go to anything to do with my case. It goes to making videos, and I might want to buy myself a box of chocolates or some perfume or take myself out for a nice dinner for my hard work on my videos. So if you want to pop something in, you're always welcome to pop something in. And if you don't want to pop something in, you're always welcome not to pop something in as well. The videos are free. But it's just if you get that feeling that you might want to do something for me, then you certainly can, okay? So that's enough of that. I just wanted to share that briefly to those people that want to contribute to lovely Kate Floss. And I won't be giving the money to the Oreo team either because I spend it myself. Sorry about that. But the Oreo team have given me a wee bit themselves anyway. So I just keep it for myself. I'll go and buy myself something. So, and I don't drink beer, but if I did drink beer, I know another guy that was doing the YouTubies, and he went and spent his money, bought himself a beer. And the people got on there and complained about him buying himself a beer. But I just say to you, whoever you donate money to, if you ever donate money, it's up to them what they want to do with it. You know, you can't control what they do with it. So you have to just give it to them and just hope that they do something useful. And you just have, it's kind of goodbye to that money. Once you've given it, it doesn't belong. So I don't drink beer, but if I did, I would buy myself a beer. And if I wanted to buy myself a beer, then that's up to me, isn't it? So, but I'll probably buy myself chocolate. So now I want to go to, I've set everything out ready to be showing you. So I want to go to the first piece. Oh my goodness, then I get lost with them. Right, I've got to turn that off and I've got to turn that off. Right, and then whenever I go to find these things, then I can't find them, can I? Ah, here. Right, so now I want all of you to not worry about these fees that I'm talking about, all right? So I'm not showing you because I want money or nothing like that. I'm just showing you so you know where we're going for the video. I don't want you to worry about the fees because the fees are irrelevant. It is the battle that we're having using the 1688 to not have to pay the fees. That's what this is about. It may well be that if they come back to me and say you've still got to pay the fees, I might just drop the case, but I'll have my answers about the 1688 already. So I might not need to proceed with the case, all right? So I don't want you to go getting yourself upset about these fees, but just know that I'll just show you what they are, okay? So now if you're on the YouTube, you can't see, but I'll be posting the, I'll be posting up the video anyway. So this is the notice of filing. So what you have is called a notice of filing. And can you see my notice of filing, everyone? Yes, you can. Right, so I'm not going to go into it too much, but what you have to do is that if you, when you leave, if you lose your case in the High Court, right, and then you want to go to the appeals court, they gave me a bill of $1,100 to enter the appeals court. And so that is one. Okay, I'm going to explain about the fees. That is the first one, is that you pay $1,100 to enter your application to the court, all right? Secondly, after that, I went and looked at the court fees, and the allocation is about have a look here on the court fees. You can't see them, but I'm going to show you later. But they give you a list of the court fees and fees of the court and the fees. Oh, I haven't got it there, so I'll give it to you later anyway. But the fees of the court are something like $1,300 for a half day. So it's not you. The judge at the appeals court will decide what kind of security that you have to put down for your case. And so for my case, the judge decided that I would pay a $7,000 security fee. And so if we calculated that at, say, if it's $1,300 for a half day, and then it's $3,000 for one day, and then we can calculate that to 6. So he's calculated it at 2 days and $7,000. So maybe another half day thrown in there. So he's calculated it at 2.5 days and possibly 3 days. And so for that, and I'm allowed to have 5 judges. So 5 appeals court, high court, constitutional judges will come to my case. And the $7,000 is not actually for the court. The $7,000 is if you lose the case, that money will go to the respondents and the Crown Counsel who had to come and fight the case. So that's who that money's there for, the $7,000. If you don't lose the case, if you win the case, it gets sent back to the High Court, and your $7,000 security fee will be given back to you. Now, I'm going to be getting to that in a minute, because you can ask for deferments, you can ask them for the fee waiver and all of those things, but they have to be done separately. Now, the next one after you get that is called a scheduling fee. And then what you'll see is that you estimate the time. I do, because it's my case. So I estimate the time that I require, which I can have an hour or 2 hours or half day or 1 day or more than 1 day. He's allocated $7,000, but if I choose to only use 2 hours for my case, I can only be billed from that $7,000 for 2 hours. If I choose to have 2 days for my case, then I can be billed from my $7,000. Okay? If I win my case, I don't pay nothing. So what I have to do is a scheduling where I contact the Crown Counsel and I say to them, I want to have this schedule, and this is how much time I think I'm going to give you. This is how much time I think I'm going to give myself. This is how much time I need with each of your respondents. All right. Now for that, that's going to cost $2,700. So now the great thing about my case is that when we were in the high court, so those 3 fees for the appeals court, you have to file a waiver separately for each one of them. Okay, and we've applied for the waiver for the first fee, which is $1,100. Now, the bad thing about the High Court, when I went to the High Court, is that they outright refused to send the respondents, Jacinda Ardern, Chris Foy, Ashley Boone. The respondents are not criminals. They're only coming in to answer a question of law, which I'm asking them about, which I've talked about in other videos, but not talk about today. But anyway, in that first High Court, they absolutely refused to come. But it was in the appeals court, when we went to the appeals court, that the appeal court judge has said, I better not put it up there, because sometimes that bit there, I better not put it up. But they have sent me the acknowledgement that the 4 respondents will come. So regardless of what happens, if I want to call those 4 to the court, they're coming. They've set the date, and I've got until the 21st of September to call them and tell them when I wish them to come. See, I'm in the driver's seat. They're not in the driver's seat anymore. When we were back in the High Court, they thought that they were in the driver's seat. But the appeals court judge just said, no, Kate Floss is in the driver's seat, and you need to be listening to what she wants you to do in her case. So this is, you see, this is the power that they have. This is the way that they've been used in the courts against all of you lovely, lovely common law people, is what somebody from the government goes down to the police station, they file a case against you, the police take that to the court and ask the court for service papers, all right? The court will give the service papers, they send them to you. Now, when that happens, they're already in the driving seat. You're not in the driving seat, and you're not allowed to turn them down. You're not allowed to say, no, I'm not coming under the common law. No, I don't reckon. You're not even allowed to, because they will send you a letter. I'll tell you about the letter in a minute. So they're in the driving seat, and it doesn't matter how hard you kick, scream, petty tantrum, call out your common law, call out your Maori law. It doesn't matter what you say. You're never going to be in that driving seat. Never. You're always going to be in the back seat, being driven around and told what to do. So in our case, it's different, because I went to the court using the 1688 Will and Mary, and I put myself directly in the driving seat. And I got the service papers myself, and I told the court what my point of law is that I'm not happy about. And the court said, yes, we agree that you've got an issue here. And the court gave me service papers. And it was me, not the court. It was me, actually me and Maxine. It was me and Maxine and Sharon, actually, the three of us. Me, Maxine and Sharon were the ones that posted those service papers, and we were responsible because we were in the driver's seat. Now, if I didn't post the service papers, there'd be no case today. So we're still in the driver's seat. We posted the service papers, and then after we posted the service papers, we got notice back. Well, they were supposed to contact us, and they said to us, we'll be in contact with you. And they never got, oh no, they just never got in contact with us, actually, come to think of it. So we turned up at the court, and we had no schedule. There was no schedule of time, because they had just outright said, in this case, was very funny, because I was in the driver's seat and they were having a patty tantrum, kicking their legs and screaming and saying, we don't recognize you, we don't recognize your law, your constitutional law, and we're not coming to meet you, and we will defy this court order. And that's exactly what they did. And then, unfortunately for me, I don't really quite understand why. Cook J struck my case out, and I never even got to argue my points of law. However, that I sent that to the appeal court, and the appeal court said, no, I'm sorry, but you're not in the driver's seat this time. This is not someone that you've sent the police to go, and we haven't served her. She has served you. And so you are in the back seat and she's in the driving seat. And Kate Floss has asked you to come to the court, and you must come to the court because the court themselves sent the service papers, right? So I'm still in the driver's seat. And then the court has sent, this is what happens to you. When you say to the court, I'm not coming, I don't recognize your law, the court then says, if you don't need to come, but we're going to carry on without you. And whatever we decide without you, that's what you're going to have, penalty you're going to have to pay. So it's best you get your little self down here, and at least you'll have something to say. But if you don't want to say anything, we're going to carry on without you. And that's exactly what the court said to my 4 respondents. They said, you will come, you will send the respondents, and if you don't do that, then we're going to carry on this case without you, and we will not give you any of the papers to do with this case. We will not tell you any of the proceedings of the case, and we'll make the whole decision without you putting in your 2 cents worth. And so 10 days later, we got the Crown, sent us the letter and said, yes, we're coming to the court. All right. So then they wanted to charge me. So now we got past that step. All right. So now we got to the step of the $1,100, and we wanted to apply for the fee waiver. Now, how do we apply for the fee waiver? So I wanted to show you the laws where we go into our fee waiver. Okay, so now I know that on YouTube you can't see them, but if anybody on there, oh, you're not able to, are you? You know what I think? Okay, what I'm going to do is, what I think I can do is, you know, I'll just tell you on YouTube, and all you need to do is Google. So I'll tell you what to Google, and you go ahead and Google it. All right. So this is what the first thing, and then I'll try and post up links later. All right. So the first thing I'm going to be looking at is the 1688 Will and Mary. So all you have to type in is 1688 Will and Mary UK, and then 1688 Bill of Rights, New Zealand. Now, I use the New Zealand one because it's easier to read, but in an actual fact, our proper common law is not called a Bill of Rights. It's called a will, and it's a will that was left to us by our ancient ancestors, and it said that our people will never be ruled over by these, they'll govern themselves, is what it says. So it's actually a will, but they've changed it of late to be called a Bill of Rights, but in fact, it was never supposed to be called that. When I talk about it in the court, I talk about it as if it is the Will and Mary, and I usually don't use Bill of Rights. But so we're going to go to the 1688. Oh, hang on, I have to stop that. So we've got the 1688, and then this is in the UK. It's called the 1688 Will and Mary, right? And then can everybody see? Oh. Right, you can see that, right? Okay, so so what you'll see there, they've changed it, they've added Bill of Rights, but in actual fact, it was called Will and Mary, okay? And so what it says here, so what I was saying to them is that what I've been saying to them in my case is that they have not been upholding the oath. And how have they not been upholding the oath? They've been ruling arbitrarily, they've been changing laws daily, they've been flooding the country with laws, they've been attempting to remove us from the Queen and make us a republic and remove our Bills of Rights, and they've been attempting to put us under the United Nations, is what they've been attempting to do. So if you go to the, I'll show you, this is the UK, and this applies to the UK, Scotland, Ireland, New Zealand, Australia. Only our 5 Commonwealth, some countries are signed up to it and some are not, but our Commonwealth countries all are, and we are all subjects. Now, it does say in there that the subjects' liberties are to be allowed, and that we are permitted. I'll go to the, they are exactly the same. For this particular case so I've got the case that is my original statement of claim, but I'm not going to be talking about that today. The case that I'm actually talking about today, crocheting around New Zealand. All right, some people are coming into my YouTube. So if you want to place a question on my YouTube, I can see you, and you can just post a question and I'll answer you. Okay, so I'm trying to work several screens here. It gets a bit hard, but okay, so the case that I have my original statement of claim, I'm not going to be talking about that today, all right? So that is separate, but that's also been taken out of the 1688 Will and Mary, okay? But the case that I'm going to talk about today is the having to pay fees, and how we can use our Will and Mary to say, hey, I don't want to pay your fees. Now, if you go to your Will and Mary of the UK, it will say here that it is the right of the subjects to petition the king and all commitments and prosecutions for such petitioning are illegal. And that, when you look at this word commitment, it says all obligations and all forcing of you to pay money. Whenever you're making a petition using the 1688 Will and Mary, then all commitments of payment of fines or whatever they want you to pay should be null and void and illegal, because it says it right here. So if your statement of claim is anything to do with the 1680, not when if you add a subordinate law, if you add a United Nations law, such as the 1990 Bill of Human Rights, if you use the 1993 Human Rights or the 1990 Bill of Rights, which is not the same as our Will and Mary, if you use those, then you can't use this to get out of your fees. You simply cannot, because the Human Rights Act is to do with workers' rights, and there is a compensation in monetary terms that you're permitted to go and ask the court for in remedy. Whereas the 1688, we're only going to ask the court about a point of law that we disagree with, such as forcing us into lockdowns, which is a forfeiture of person without conviction, or forcing us not to speak about something that is a violation of your freedom of speech, forcing us to have injections of substances that we don't want to have. That's a cruel and unusual punishment. All of these things come under the 1688. But if you go and use that 1990 human rights, you won't be able to ask for a sidetrack of your fees. So I'm going to go now to the 1688 Bill of Rights of the New Zealand legislation. Now it's exactly the same. It is exactly the same, except it doesn't say Will and Mary. Now, when I use it, when I go to the court, I use the words Will and Mary, but they are exactly the same, and it comes under the Imperial Laws Act. And I just use the New Zealand Bill of Rights 1688 because it's easier to read. So that you can go down here, and so you can click on, oh, just shared your link. Thank you, Crocheting Around New Zealand. Yeah, and if you're able to post up on your thing there, like I think I can actually post it here. Let me see if I can post it. So here is the, I think I can actually. Oh, look, so that is, I've just posted up the 1688 Bill of Rights, New Zealand, for our YouTubers. And then I've just posted up, I'm just about to. Right, so here is the 1688. Okay, there's, I can't post up court documents, but I can post up these for you. All right. So, so you can go to your 1688. Try to get through this as fast as I can for you. Sometimes it's hard to get through these things, but just do your best. All right, we're going to try and make this a 1 hour. So, all right. So on the 1688 Bill of Rights, the way that it says the subject's rights now, it says that it is the right of the subjects to, all right, I'll put it up like that. So it is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal. All right, so that's what it's saying there. Now, along with that, there's something else here that you're going to need, and this is called the Declaratory Judgments Act. All right. Now, the declaratory, this is an Edwardian law of King Edward VII, and this is in our legislation. So here's King Edward VII. So this is called Oh, the rats are here again. Oh no, get out, the rats. Oh, okay, so this is called the Declaratory Judgment Act, okay? And then you've also got, so this is the one, this is the one from the King Edward VII. And you'll see here, it's called Declaratory Judgments Act 1908. And you'll see it's called the Declaratory Judgments Act. And you'll see here that it says a person, where any person has done or desires to do any act, the validity, legality, or effect of which depends on the construction or validity of any statute or any regulation made by the governor in council under statutory authority, or any bylaw made by a local authority, or any deed, any will or document of title, or any agreement made or evidence by writing, or any memorandum or any article of association of any company or any body corporate or any instrument prescribing the powers of any company or any body corporate, where any person claims to have acquired any right under any such statute, regulation, bylaw, deed, will, document of title, agreement, memorandum, article, or instrument, or to be in any other manner interested in the construction or the validity of thereof. So it's saying there doesn't even need to be a problem with the law. You only need to have, as a person, a question about that law and why they made that law, and if it is repugnant to your 1688 will and Mary. If you think that that memo, now this can be a memo from a government website, it can be an article from a newspaper that the government has made an announcement about. It doesn't even have to be a law. It can be any piece of paper where they have written on that piece of paper as a government official that if it's repugnant to your 1688 will and Mary, then, and you don't even have to be wrong. You only need to be interested in that law. You're permitted at that time to go to the court. And they've been telling us that we're not permitted. So I'm here to try to prove them wrong. That's what I'm trying to do. So then it says, any of those things where any person is interested, only interested in the construction or validity thereof, such person may apply to the Supreme Court by an originating summons returnable in the said court for a declaratory order determining any question as to the construction or validity of such statute, regulation, bylaw, deed, will, document of title, agreement, memorandum, article, or instrument, or any part thereof. So that you've got this here document here that is saying to you, now, as I've said to you before, this is no good to you if you're using, now, I'm going to show you the difference in a minute. We're going to go and look at some UK laws, and I'm going to show you the difference in a minute, that when you use the 1990 New Zealand Bill of Rights, Australia's got a 1990 Bill of Rights, UK's got a 1990 Bill of Rights, Scotland, all our Commonwealth countries use exactly the same laws. So if we've got it, you've got it. And if you've got it, we've got it. And this is why we have to keep our Commonwealth sorted out, because they make the law in New Zealand, and over in the other 4 countries, you're not watching while they make the law in New Zealand. And then they institute it and pro-acclimate it in New Zealand. And once it's all done and dusted, then they send it to your 4 countries. They do that once or twice in New Zealand. Then they hop over to the UK. They make the law in the UK. They have a case in the UK. They have a law in the UK. They pro-acclimate it. They put it into the writing, and then they send it over to New Zealand and Australia. So that's how our countries are creating these laws that are getting us all entwined into this United Nations, because they're moving between countries. They do one in New Zealand, then they do one in Australia, then they do one in England, then they do one in Scotland, then they do one in Ireland. So we've got to keep an eye on each other in the Commonwealth and start looking at what's going on. So now where am I going here? So getting back to our declaration, so any document. So then, so if you come under the 1990 Bill of Rights, which is a workers' rights and it's connected with the United Nations, you can use it for this, but this is an Edwardian law. So it doesn't really have any power over the United Nations, all right? So this is from King Edward, and the 1688 is from the King, but the United Nations, who set up the United Nations? That was set up by America, and America is not under the King's law. So they're under a different law. So some of these things can be, they use this sometimes for their United Nations law, but they're not actually supposed to. This Declaratory Judgment Act was actually created, even though we have it here in 1908, it actually was created in the time of King Edward VII, okay, which I don't know what date that is. I think it's 1808, actually. So this was just a consolidation, and they updated it, but the declaration stayed the same, but they just brought it forward to the present time. That was because in 1908, they changed from the King, I think, and changed to the Queen, and there's some different things going on around there. So anyway, under the Declaratory Judgments Act, then actually, if you go down, so you have this in your, actually in your legislation. So I'll see if I can copy this and send it. So this is the legislation of New Zealand. I hope I haven't reposted things, but there I've posted it down so you can see there. So you can open those if you want. So this is the, who's that?
Moxie Hero.
Hi, Moxie Hero.
Hey.
All right, I've just got to keep going. We're kind of a little bit through, but you can try and catch up, dear.
I'm gonna just listen. This is my first
All
time.
right. All right, well, you just be listening and I'll be telling. All right. So
that guy next in there, he's super cute. You think he's super cute?
All right,
And-
listen, we don't want you, listen here, Moxie Hero, we don't want your
Yeah.
nonsense in here, so you'll have to bugger off if you're going to be causing
I
nonsense.
didn't know my mic was on mute. Sorry.
Yeah. Okay, right. So, the Declaratory Judgment Act. All right. Keep an eye on that one. All right. So, so if you go to the Declaratory Judgments Act in its New Zealand legislation, what you'll see is costs. And what it says here is that the costs of any action, summons, or appeal. How's that? How do I throw them out?
Do not
I
call me.
need some. Mute them.
No, be
Mute
quiet.
Right. If
You ain't gonna
anybody
keep me
disturb-
wrong. I'm gonna kiss you.
Now fry them out or turn it
I'm
off.
about to start
Turn it
working
off.
on
how do I do it?
Give me a kiss, Daddy.
They're American. They can piss
What's
off.
the Americans?
Oh, they're gone.
Are they gone? Yeah, she. All right, they're gone. All right, they're out. Okay. Okay, so costs. The costs of any action, summons, or appeal under this act shall be at the discretion of the court, and the court may, in the exercise of that discretion, order the whole or any part of those costs be paid by any party, although successful in the action, summons, or appeal, and may in any case direct that costs awarded to any party shall be taxed, either as between party and party, or as between solicitor and party. Now, this is interesting. This, even if you win the case, they can order you to pay costs, or if you lose the case, they can order you to pay costs. It's up to them, and they're claiming that if it's not in the public interest, so I'm going to show you a case soon where it wasn't in the public interest, and if it's not in the public interest, then they say that they can order you to pay costs anyway. Now, stay with me on this. We're going to be working from multiple areas of law. So you all going to have to just kind of stay with me on this. And so there was a case in 1975 where Fitzgerald versus Muldoon, which I'll go and talk about it in a minute, but he had taken the Prime Minister to the court and he won his case, but the court made him pay costs anyway because it wasn't in the public interest. And when I'll get to showing you in a minute that I've challenged that, I'm saying to them that it was illegal what they did to him. And this is going to be a landmark case already. Only on the $1,100 is going to be a landmark case because I have challenged them and I said that they wrongly forced him to pay. I'm saying that anytime that you make a petition to the court in regards to a repugnant law that involves the 1688 Bill of Rights, I'm saying that they can't make you pay money because it says right there on the 1688, it says it, that it is the right of the subjects to petition the king. Now, before you can, the courts, every single judge, every single parliamentarian, every single governor general has their position rested on the oath. So their oath of office, they have to make an oath of office, and before they make the oath of office, okay, and it says here, for frequent parliaments of all grievances and for the amending, strengthening and preserving the laws, parliaments ought to be held frequently. And they do claim, which is us, we, the people, they do claim, demand and insist upon all and singular the premises as their undoubted rights and liberties, and that no declarations, no judgments, no doings, no proceedings to the prejudice of the people in any of the said premises ought in any wise be drawn hereafter into consequence or example, to which we demand of their right. They are particularly encouraged by declaration of His Highness the Prince of Orange as being the only means for obtaining a full redress and remedy therein. What does this mean? That means when you see a point of law, you go to your Declaratory Judgment Act and you go to Section 3, and when you see a point of law in any regulation, statute, bylaw, deed, will, document of title, agreement, memorandum, article, instrument, or if you're only even interested in a law and the construction of such law, all right, then you are permitted to go to the court, and the only means for you to have that law correctly questioned that will be binding in law is to go to the court and ask for a declaration. So if you have a question about a law, and you write a letter to the Parliament, so you have You have a law and you have a law and you have a question to the Parliament about that law. It doesn't need to be that it is a proper law or that it is right or wrong. There is no right or wrong. You have a question about that law because you need to use that law for some reason or another. If you write a letter to the Parliament, a letter of petition to the Parliament can look at your letter and they can send you a letter back if they want to, or they don't have to if they don't want to. They can send you a letter back and they can tell you that you're wrong, or they can send you a letter back and they can tell you that you're right. But the letter that you've got, you might as well go and wipe your backside with it for all the good it will do you. It's not binding, that's Kate Floss talking, it's not binding in law, and it's of absolutely no use to anybody around you except for you as an individual, that they said you were right or they said you were wrong, and you can go around and show it to your mates, but it's not binding in law. Whatever they wrote to you, even if the Attorney General wrote it to you, even if the Governor General wrote it to you, it wouldn't be binding in law. It's just a letter to say, yes, you're right, no, you're wrong, yes, this is the law and this is what it means. The only means that you can truly know if a law is, if the question of law that you have is if your question is valid or if you're right or wrong, or they are right or wrong, is to go to the court and get a declaration under the Declaratory Judgment Acts. So that's what they're saying. And what they're saying is, what I'm saying is this: if the Parliament makes a law that causes you to go and question it, if it's so dubious and if it is repugnant to our 1688, Will and Mary, if it's repugnant, they shouldn't have made that law in the first place, because the 1688 is in the cabinet manual of each of our countries. And the Parliament think that they've got parliamentary sovereignty, but they don't. They only have parliamentary sovereignty if they're upholding the oath and making laws that are in sync with the oath. And whenever they make a law that's not in sync with the oath, then we are permitted to go and to get a declaration. And if their law has been made repugnantly, then they should never have made it in the first place. I'm saying they should never have made it, so they have to be responsible for that law. And so why should I have to pay for that? They shouldn't be making laws that cause me to question and cause me to be in fear. So they're making many laws to cause us to be in fear, and they're not supposed to do that. So so that I said, so that you see here, can you see my screen, everyone? So that you see here that the subjects, that it is the right of the subjects to petition the king, and all commitments and all prosecutions for such petitioning are illegal. That basically means if you don't pay the fee that they've told you to pay, then a prosecution for that is also illegal, because you made a petition in regards to this 1688 Bill of Rights, and then it was due to their incompetence, okay? And so that's how you use the Declaratory Judgment Act together with your 1688 Bill of Rights in each of our countries, or the original one is called the Will and Mary, and I usually quote from the Will and Mary. Now, I wanted to show you another case here. Right, so I'll put that on with March. So I will share this here about, all right, so I'll share here an example, okay? Okay, I don't really want to lose this, but I think I can. All right, so I'll post this up on the YouTube, if you can see it. So this is called, and I'll share to my screen. Where's my screen gone? Got so many screens going on here. Right, I've got to, all right, you've got it. All right, so I don't need to reshare that. So this one is called the Onward March of Declaratory Relief. And why are we having so much problems with our declaratory relief is because that they've been using it with United Nations laws and with the 1990 Bill of Rights. And they're not actually supposed to be, because it's an Edwardian law, and they're supposed to be using it with the King's law, which is here, the King's law. And what they've been trying to do is to use it with the 19 Bill of Rights, and it's gone pear-shaped. It isn't working. So this is called Onward March of Declaratory Relief of Paul Daly. So what happened was 100 years ago, noted that the emerging concept of the declaratory relief could provide a speedy and easy access to the court for any of His Majesty's subjects. We were always supposed to have access to the court. It was never supposed to be taken from us. The courts, why were the courts originally set up? The courts were originally set up so that the subjects could keep an eye on the parliamentarians that were governing over them. But somehow they've turned the courts into a paste of criminals, rapists, murderers, all of these kinds of things. And the court has lost its purpose. And I'm going back to the court to ask them to refine their purpose. The original courts that were very first set up were set up so that we could go to the court with our 1688 and hold parliamentarians to account when they thought that they had parliamentary sovereignty, and they were not supposed to make any laws that were repugnant to our safety. Is that what they were not supposed to do? So then they created the Declaratory Judgment Act to give us more access to the court. And the proceeding by declaration can be highly convenient. And indeed, it can guide public bodies for action in the future. Dyson and the Attorney General, and of course, two of the most celebrated administrative law decision of Regin Baldwin and Annie Seminek foreign compensation were actions for declarations. Two recent examples, one was British and one was from New Zealand. Now here's where you're going to see where New Zealand's been a sneaky. Suggests that the intensity of the onward march shows no signs of abating. Here in Britain, the government is fighting to prevent the Court of Justice of the European Union from delivering an advisory opinion on whether it is possible to revoke the Article 50 notification that will cause by operation of law Britain's departure from the EU. I'm not quite sure what was happening there, but they were, this is a case that Britain is more familiar with. I'm not familiar with, but you can guarantee that it was at this point of time, Britain saw that they needed to fall back on their, Will and Mary, and it's brought the Will and Mary to the surface again. And then they would have needed to, Oh, Brent, just turn off your sound and then you can listen.
Oh, sorry.
All right. So, hi there, Brent. All right. So, so we're talking about the 1688 Bill of Rights, Brent, and they're trying to make us pay the money to get into the court. And our first point of call is to battle, and we're saying we don't need to pay the money, because we're saying here that it says here that it is the right of the subject to petition the king, and all commitments and prosecutions for doing so are illegal. Okay, so we've used that to say that we don't need to pay. And then we've used also our Declaratory Judgment Act on Section 3 that says that if we have a question about any bylaw, deed, will document, that we are permitted to question them. And then we see that when Britain tried to leave the European Union, there was a question about Article 50, Notice 50, and they had used their Bill of Rights 1688, and they had used the Declaratory Judgment Act Section 3, and this has brought it all back again. And now my case is also going to it's all going to come to the forefront, which is what we wanted. So it really doesn't matter if we win. What we wanted to do was to get everybody's attention on our true common laws and get everybody's attention away from the subordinate 1990 Bill of Rights, which is not our true common law from God, our constitutional law. So, so they used it in Britain. Now, it followed also that there would be no interference with parliamentary privilege, because the use to which the declaration would be put would be entirely a matter for the Parliament. And Lord Drummond put it, the courts would simply be making a statement of existing law, well within the usual constitutional function. Oh, hang on. I'll have to go back a bit. I think I will read this. I wasn't going to, but I will. The underlying issue arises from the decision of the Inner House exiting the European Union. At first instance, the Outer House had refused to make a reference to the Court of Justice, reasoning that the issue was entirely academic, given that the UK government's stated unbending policy is not to revoke or even consider revoking Article 50, and an interference with proceedings in Parliament in violation of the principle of parliamentary privilege. Parliament is saying we can make any law that we want with our parliamentary privilege, and since we have parliamentary sovereignty, the people vote us in, we can make any old hecky law that we want to, and nobody can stop us, not even the courts, not even the Queen, not even the King. That's what they're trying to say. The Inner House took a different view on both points, and from Lord Carlaway held that the matter was not academic, irrespective of the UK's policy position. It is clear in terms of the European Union that MPs will be required to vote on whether to ratify any agreement between the UK and the EU Council. If no proposal is proffered, a vote against ratification will result in the UK's departure from the EU, a date which is looming. It seems neither academic nor premature to ask whether it is legally competent to revoke the notification and thus to remain in the EU. The matter is uncertain, in that is the subject of dispute. As this litigation perhaps demonstrates, the answer will have the effect of clarifying the options open to the MPs in the lead up. Now here is a clear example. Here you've got an outside law that has been brought into Britain, and the British people are responsible for it, and the British people are saying, can we use our inside laws against that outside law? If we use our inside law against that outside law, well, nobody will ever trust us again. It's kind of a difficult one, but this is what had happened. So it followed also that there would be no interference with parliamentary privilege. That they're saying that you can't use the 1688 to interfere, or you can't use the Declaratory Judgments Act to interfere with parliamentary privilege. So that's a little bit conflicting, because the Declaratory Judgment Act says if any law is repugnant to you, you can go to the court and get a declaration against that law. But parliamentary privilege is saying, well, no, you can't do that, because if we make a promise with outside people and we don't uphold it, then we'll have many problems with the international. It's kind of, I don't really know. I don't know. This is not for me to decide. This is for the courts and the judges, but I'm just throwing in my spoke in the wheel for the commoner. So the courts, so he said, Lord Jummer put it, the courts would simply be making a statement of the existing law, well within their usual constitutional function. So the courts, here the boundaries of declaratory relief are being very broadly drawn, admittedly as a matter of the Scots law only. No facts are in dispute, no rights or interests turn on the resolution of the question, and no legal consequences follow from the issuing of a declaration. This is the thing. When you get a declaration from the court, it really depends if it's only an internal law or if it's an international law and how it affects things. So it depends if the declaration can be useful or not. I'm not quite sure. Were Parliament somehow to direct the UK government to revoke Article 50 and meet resistance on the ground that the notification was irrevocable, the question would no longer be academic. But the inner house, which is inside Parliament, declaratory relief would be appropriate in any event based on the desirability of ensuring that MPs are fully informed of the suite of options at their disposal when voting to ratify an international treaty. So here's what they've said. This is great for us. What they've said is that it's an outside law that we've made commitments to and promises to, but here's our Declaratory Judgment Act of the inside law, and how would that affect the outside law? Because we made the promise, right? But what they've said is, if we get this declaratory judgment in favour of England to get out of the thing that they want to get out of, it wouldn't have to have an effect on the outside law. It would only just be another tool that Parliament could use in combating the outside law that they want to get out of. So it would just really give them permission from Britain to do the thing that they want to do, but it wouldn't get them out of the international obligation completely, but it would get them firm in England, all right? And that's the problem that we've got with this United Nations human rights law and 1990 law, is that this is an international outside law that our countries have made obligations to. However, it's affecting terribly the people that are on the inside, and it's repugnant to us, you see? So we can still go and get a declaration, they said. Now, that's all I'm going to say that, but I'll go down to the New Zealand case. In the New Zealand case, Attorney versus Taylor, at issue here was New Zealand's legislated blanket ban on prisoner voting. It was accepted that the ban is inconsistent with the New Zealand Bill of Rights Act. And in this case, they used the New Zealand Bill of Rights Act, and the only question was whether courts can grant a declaration for the New Zealand Bill of Rights Act, which is not. So here's the New Zealand Bill of Rights Act. Now, this is not a constitutional law. This is a so I've posted that up for the YouTubies. So the Bill of Rights Act is not a constitutional law, and it has, in our Bill of Rights Act, it has justified limitations 3, 4, and 5, and many restrictions on it. But we don't come under this, as I've told you. We come under S28, and S28 says that our other rights and freedoms are not affected by any of the laws in here, just because it's not in here. So what it's saying is that this Bill of Rights here of our 1688 and this Declaratory Judgment Act here is never going to be affected by any of the decisions that they make in regards to Section 19 and the Human Rights Act. So that goes to the Human Rights Act, okay? And so, and then that Human Rights Act goes to KII, the desirability of New Zealand becoming bound by any international instrument on human rights. And I'm saying that this is repugnant. This is repugnant to us. And that is my first case, but presently we're not fighting that today. Today we're talking about getting out of the fees. So we come under S28. So therefore, this Bill of Rights is nothing to do with us. But they used the Bill of Rights in this case, and then they wanted to get a declaration the same as what we can get. And so in this one, there was a 3-2 majority that the Supreme Court would have the power to issue a declaration in the 1990 Bill of Rights. You can call it the Human Rights Act. They would be able to issue a declaration, but they said from previous case law deduced a principle that an effective remedy should be available for a breach of the Bill of Rights, and the courts can draw upon the ordinary range of remedies to provide a remedy. So the remedy for them is a payment. The remedy for us is that the law must be changed, and we can order ministers to stand down, and we can order governor generals to stand down, and we can order prime ministers to stand down. But for this one, there is only a monetary remedy, and they might change the law for them, but they can't. It's not significant what they can do with it. The courts can draw upon far from being in tension with the orthodoxy underpinning the Bill of Rights. The text and purpose of the legislation supported the view that courts could issue declarations of inconsistency. In concurring her judgment, Elias C.J. noted that the statute given the New Zealand court's jurisdiction to grant declaratory relief under the Declaratory Judgments Act provides for binding declarations of right. But regardless of whether consequential relief has been claimed or could be granted, she describes, puzzlingly, she describes this as part of the inherent jurisdiction of the courts, and people are questioning that, notwithstanding its statutory basis. So she's saying the 1990 is not a statutory legislation, but we can give them a declaration, and that will allow them to go and get their remedy. However, to the argument that using a declaration would be entirely academic in a context in which the meaning and effect of the ban on presidency voting was uncontested, the majority offered a comparatively weak set of reposits. It says that in regards to the disqualification to vote being inconsistent, so if they got the declaration, if you got a declaration under the 1990 or under the Human Rights Act, if you got a declaration, where could you take that? It would not have any effect on the New Zealand Parliament or the New Zealand Court or the New Zealand laws. All it does is facilitates the making of a complaint to the International Covenant on Political Rights at the United Nations. It serves the purpose of marking and upholding the value and importance of the right, and it gives some protection against any attempt to relitigate the question of consistency. These consequences are only symbolic. So if you get a declaration under the New Zealand, under the Human Rights, I'll use the Human Rights Act for want of a better word. If you get a declaration under the Human Rights Act, all it says is that you can never litigate against this law again, and you can take it and file a complaint at the International Covenant of Political Rights over at the United Nations. That's all you can do with it. And all it is symbolic. It means nothing. But that is not the case with our 1688. Here's the confusion. Under our declaration, ours is a binding declaration, And so I've made my complaint, and I have said to them that it is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal, right there. And then you can go to the subjects' liberties to be allowed. And this is what happens when the court issues you a declaration under this one here. It says that this is your indubitable right, and so it shall be esteemed, allowed, adjudged, deemed, and taken to be, and that all and every the particular aforesaid shall be firmly and strictly held and observed as they are expressed in this said declaration, and all ministers, all officers, all ministers whatsoever shall serve their majesties and their successors for all times to come, which means whatever that law is that is repugnant, it has to be stood down immediately. It ceases to, they have to stand it down, they have to remove it, and they can never, ever, ever make a law like that ever again. So that is the difference, all right? So what they had done over here in the Onward March is that they had used the 1990 together with the declaratory judgment. But what we need to use is the Will and Mary together with the Edwardian, the 7th law here, which is a little bit different to the legislation, okay? It's a tiny little bit different because these are given to us by the kings here. The 1688 Will and Mary is given to us by the king, and the declaratory judgment 1908 is given to us by Edward VII. So that's an Edwardian law. But if you're going to use that 1990 little sneaky, then you're going to use your declaratory judgment, but it isn't going to have the same powers at all. It's merely symbolic. And then they tell you again that it's symbolic. So the declaratory relief thus continues its onward march. It has travelled a long way from Dyson, where it was given in respect of statutory powers to interfere with individuals' rights and interests. The judges in both of these cases have taken an extremely broad view of the circumstance in which a declaration would be appropriate. No doubt these cases will be prominent in future attempts to convince the judges to take declaratory relief a few more steps forward. And that's what we've done, because we're asking. So I'll put that away. Right, this is going to be about another half an hour, people. So everybody's left the YouTube, but you're all here. So thank you for sitting. So that is the Dyson. Now, all right, I've already done that, haven't I? Oh. Right, so this is one of the places that they had stopped me. It's interesting underneath it that they've got the word help refugees. So they want us to be rid of these laws because they know it's going to help the refugees a lot, which I'm happy for them, but it isn't going to help us with all the things that the United Nations has said, that they can have houses and jobs and benefits and languages and schools and their own schools. We have to help them build the temples, all of that. That's what helps them. So they've surrounded it around, but this is Dyson versus Attorney General. This was in 1911, and Fletcher Moulton considered the rule allowing a case to be struck out as an abuse of process. Now, we were struck out because of the abuse of process. So I'll just put that up for those who are interested. to see it. So we also, as common law, were struck out because of abuse of process. And what it was is Fletcher Moulton considered the rule allowing a case to be struck out as an abuse of process. And what they're saying is now it is unquestionable that both under the inherent power of the court and also under a specific rule to that effect made under the Judicature Act, the court has a right to stop an action at this stage if it is wantonly brought without the shadow of an excuse, so that to permit the action to go through its ordinary stages up to trial would be to allow the defendant to be vexed under the form of legal process when there could not at any stage be any doubt that the action was baseless. So they have to prove that your cause of action is absolutely, undoubtedly baseless. But he says here, to my mind, it is evident that our judicial system would never permit a plaintiff to be driven from the judgment seat in this way without any court having considered his right to be heard. So they have to consider my right to be heard, which they did not do. Better star that, as Sharon will tell me. Star that, Kate. My right to be heard was removed from me. And they said that I didn't have a cause of action, but I did have a cause of action and I dispute that. And the judge is the judicial, they're supposed to consider very carefully, having considered the right to be heard, excepting in cases where the cause of action was obviously and almost incontestably bad. I don't think, and then this is what's going to be in my appeal, is that they're going to have to try and show that my case was absolutely incontestably bad, and that there was just no chance that even if I was heard, that there was going to be able to make any rhyme nor reason. But I believe that Section KII is a reasonable dispute, and I have the right to question that, and I believe I have the right to be heard, and I believe that I have the right to have an answer to that question by the court and the Prime Minister. Why have they signed our countries up to be bound to any and every international instrument on human rights? What if they say that it's their right what if they say that it's their right to have $50 million sent to their home country every 3 years to assist their families and assist all of their people? And what if they say that that is their right, which is what they're actually doing, by the way? They're saying that it is their right to get assistance for their families. It doesn't say those families have to be in the country with them. Those families can be back in their own country, and they're saying that it's their right. All right, so I'm gonna talk with this person. So they're saying that it is their right. So we told you, this is Betty, I'll just call Betty. So Betty's made a comment here, and Betty says, we told you the Crown comments is a corporation and not the Queen. We all New Zealanders have been stolen our rights and freedoms. Well, this is what we've gone to the court, because we're not doing the Mannix law today, Betty, but we got struck out because of this reason. They said they struck us out on the process of the court, and you probably weren't here earlier, but I did explain it. And it's this, that they said my case was unintelligible. But here it's saying that according to other cases, they have to really seriously consider your right to be heard above all else, even above the respondent, because it's only asking for a declaration, and the respondent is not being charged with any criminal charge. The respondent is only, as a parliamentarian, being called in about a question of law. So the judge has to err on the side of the plaintiff, who only wants their question of law to be answered. That is all. And so therefore the judge has to air. So when we went to the court, the judge and the Crown Counsel said that the court should err on the side of the respondents because it's going to cost them their time. But they are a parliamentarian and they are paid $400,000 a year to make laws. And if they've made a law that's repugnant and has caused me to be in fear, under the 1688 Bill of Rights, I am permitted to call them to the court and ask them to answer my question. And in my case, the court must consider my right to speak. It's only the right to speak above all else, and not consider their right of wasting their time, because we pay them $400,000 a year to sit there. So their time is paid by me. And so they have to come to the court and answer to me, because they should not have made the law in the first place. Now, Betty has said everyone's been stopped from coming to the court because they said you're a corporation. Now, that's the Manic Law, and I'm not going to address that today. But what I am going to address is they said that you have to have a solicitor, but you can certainly go to, I'll just put it up one more time for Betty to see. This is what we went to, or I went to, and I'm saying under the declaratory judgment here, it doesn't say that you need to have a solicitor. It simply says any person, and it says any person 3 times, right? 3 times. Where it's a corporation, if you're using this 1990 Bill of Rights, this is very, very different, because on this one, you're permitted to apply for remedy, which can be in a monetary form. And in this one, the declaration is only going to and so the corporation is us. And whenever us, as the owners of our corporation of New Zealand, whenever we're going to be forced to pay money to somebody, because we are the owners of the corporation, we are entitled to be represented by a solicitor. And so before that money can be given by the judge. So that is why on the 1990, if you're going in there on a 1990, you need a solicitor. But if you're going there on the 1688, Will and Mary, and also the Edward VII declaratory judgment, at that point, you're going to address the oath that the corporation must uphold in order to make the laws in the Parliament, in order for them to make the bills to give to us. So I've done this in another video. It's in an earlier video. I'm not going over it today. But so we are addressing that in my court case, the Cape Frost court case. We are addressing that. Now, where are we up to? So now I'm going to go to all right, I'm going to go to, now I'm not able to post this bit for you. I'm going to close that, and all right. So where I'm going to go now is, oh no. All right, now where's my Zoomie? Can't find you. All right, I just need a wee minute to sort out my screens. Where are you, everyone? There you are. All right, I'll put you over there. Right, I'm going to go to the court document where I'll explain to you. Now I can't post this, so you can see it on the Zoom. So the Court of Appeal, I had applied to the court for a fee waiver, And the court had answered back to me here. So he had said, I acknowledge receipt of your application for the first fee waiver, all right? And so he had said, under the court regulations, I'll be able to post these up for you in a minute. Court of Appeal, I'll post it for you now, actually. So I'll post this up, and if you're on the YouTube, you can go and get it. So I'll just copy that for you. Now, where's my YouTube? I've lost you now. All right, here's my YouTube. Right, I'm going to post this for you on the YouTube. So this is the Court of Appeal fees regulation that you'll have there. So you can go and have a look if you want to. It's all posted up there. So if you go to the Court of Appeal fees regulation and you go to section 5, it says under regulation 52B, it concerns that you must have a matter of genuine public interest. And then you also, he said, and under, it must come under the criteria of 54A and 54B. And then what he says is, he says that the criteria of 54A and 54B were not satisfied. And he said, he said, you have to have a group. He said, it is the requirement, the failure to meet the second requirement. He said that you can only apply for a fee waiver if you are applying as a group. And he said, you didn't apply as a group, you only applied as a singular person. And so he said, your application for fee waiver was declined, is what he said to me. So there were two things that he said. He said, I didn't apply as a group and I only applied as a singular person. That's number one. And secondly, he said that my case was not in the public interest, okay? Now this is going to be, I'm going to turn that bit off from him. So he said those two things, it's not in the public interest. And secondly, he said that you have to be part of an organization that is set up by the government that goes to the court about these things, okay? So now I'm going to show you now where did I put it? I think I just turned it off. Oh no. I've just got to show this. Oh, here you go. Okay. Right, I've got it. Okay, we'll go to. So I just want to show you this. It's about another half an hour, I hope. Yes, 25 more minutes. So, and then we want to finish it up. So I'll show you this and you can go back and look at it later. Are we still recording? Yes, still recording. Right, here's the Court of Appeals fees, all right? And then, so in the Court of Appeal fees, and you go to the power to waiver, and then he says he struck us out in the case of 54A, that says, for the purposes of these regulations, which is a fees waiver, a proceeding must concern a matter of public interest. And that is a proceeding that has been or is intended to be commenced to determine a question of law. And then he says that is of significant interest to the public or a substantial section of the public. Now you can go to your 1908 Declaratory Judgments Act, and you can see here that it says no such thing. So they have added that on because it says here where any person has done, or where any person claims, or one person. So in this case, it can be a person. So I've talked about this already. So I've said that he's wrong in that case. And then they've used significant public interest again, okay? Now, I already did a video about that, and I don't really want to talk about it extensively today, but I'll get to the final bit that I really do want to talk about today. And I'll go back to, I'll stop the screen share of that. So he said, you need to have significant public interest to get a fee waiver. And he said, you need to be an organization to get a fee waiver. And then in the first court, they said, you need to have a solicitor because we're a corporation and we will not let you into the court without a solicitor. So there's those three ways that they're blocking you. So I want to take you now to a case, another case. And so this case was done in So I'm going to the Bill of Rights here. Right, so you'll see here that we want to go to it. We see here the right to petition and all commitments for such petitioning are illegal. And we want to go to this case called Fitzgerald. Now I'm going to post this up versus Muldoon. Now I'm not going to read all of this, but you'll be able to, I'll post it up for you on the YouTube. And this case is called Fitzgerald versus Muldoon. And this case here happened in 1975, I think. And I'm not going to read it all, but I'm going to tell you just a little bit. So Fitzgerald versus Muldoon happened in 1976. And he said that Prime Minister Muldoon had breached Section 1 of the Bill of Rights 1688. He said that the pretended power of suspending laws or the execution of laws by regal authority without the consent of Parliament is illegal. Now, we did get a book from, oh, Maxine, I wish I could find that of you. Now, I can do it on my case. So he went to the court, Fitzgerald went to the court, and he did in fact win his case, but he ended up with a bill of $3,000, all right? Now I'm going to go to you that case because I have gone to the court. So let's see now. Here, all right. So if you know that Fitzgerald versus Muldoon case, I'm going to share screen. Can you see my screen? Right, so if you're on the YouTube, you're not going to be able to see what I'm talking about, all right? So I'm going to have to just read it to you. So what had happened is, in Fitzgerald, in a book called Challenge, Challenge and Change, Judging in Aotearoa, New Zealand. It was a book. The people that contributed were Chief Justice Winkleman, Chief Justice KOS, and it was written by LexisNexis. And what they said on page 118 and 19, they said that a humble young public servant thought that the law was wrong. He stepped forward as no one else would, and no group was prepared to stand alongside him in the trench. That's like me, isn't it? The fee he was charged was $3,000, or in today's money, $23,500, which was more than half of his salary. Now, his case, even though it was calling the Prime Minister to account of a violation of his right under S1 of the Bill of Rights 1688, had garnered no public attention. So they had said, in his case in 1976, Fitzgerald versus Muldoon, they had said, you have to pay the money anyway because it's not in the public interest, and nobody was interested in this case. Now, his case has gotten, it's been quoted hundreds, well, I won't say hundreds, but dozens upon dozens upon dozens of times. His case has been quoted, it's been used by judges, it's been used by lawyers, it's been used in books, it's been used in the UK, it's been used in Australia. His case has developed a public interest over decades, and presently it is the top go-to case. And poor old Mr. Fitzgerald had to pay the money to the court, and because they said, even though you won the case, you still have to pay the money because there's no public interest in your case. Well, the public interest has come decades later. So I've said to the court, I've used that it's the right to petition the king under S1 of the 1688 Bill of Rights, and that all commitments to any such petition are illegal, which means any demand of money for me to do that is illegal. So they're trying to squeeze out of me altogether. So far, we're up to $14,000, but I'm only fighting the first one of the $1,100. So don't worry about the other ones. So I'm waiting for the outcome of the 1,000. And then if I win that, I might be able to use it in the other ones, but let's just wait and see. Hello, Philip Bridge has come to visit me. So I said to the judge, here we have a singular person, as is permitted by the declaratory judgment, with no substantive public backing, wishing to go to the High Court to claim his right to question the validity of a law or announcement of a Prime Minister. That was Prime Minister Muldoon. And I claim that Fitzgerald should never have been charged High Court fees, as under S1 of the 1688 Bill of Rights, right to petition, all commitments to the court or the state are illegal when petitioning for a declaration of right in this 1688 Bill of Rights, Will and Mary. I've called the Will and Mary. I also claim that in S1 of the 1688, the subjects' arms, that the subjects which are Protestants may have arms for their defence as allowed by law. And I'm saying that the arm of defence of Protestants in the common law is the unobjectionable, unquestionable right to pray for a declaration by the court to affirm their right and affirm and to answer their questions of law. When any repugnancy is questioned, we've got that right to go to the court and ask. So when a question of, and I've said to them, I think this is brilliant, my final piece, I've said to them, the Fitzgerald case, just like mine, was deemed to have been to be of little public interest. And I said, and yet here we are, 47 years later, still reliant on his case for guidance. And I said that the registrar may not see significance in the present day, but the significance to the public, in my case, may evolve exponentially to the public and the Commonwealth over time. When a question of repugnancy in the law has caused fear to such person to the extent that a desire to petition is deemed necessary, then such petition must be free of commitment to the said petitioner, and the lawmakers, now yes, the lawmakers must be held accountable to the causation. When the Prime Minister or the Parliament have written laws to cause you, the public, to have fear in your person, then it is your indubitable right under the declaratory judgments of the Edward VII, it is your right to go to the court with the question and ask them to answer your questions so that you won't be afraid. And they're the ones that wrote the law. They used your taxes to use the time to write that law that caused you to be fearful or caused me to be fearful. And so I should be allowed to go to the court for free. Thank you for sharing your very much interesting watch. So we're coming up nearly to the end. So I've since then, I've had a letter from the court, and so I'll just be announcing the new letter for the court, because I want this to be a public court hearing, but it's not good news, but it's not bad news. So, and then this will be finishing up, and we'll finish up exactly on the 30th, I think, if I get this done quickly. So I have had the letter from the court, if I can find it in amongst all of my bits that I've got up here. I've got lots and lots and lots of bits. If I have to find the bit that I want, which is particular. Aha, I have found it. So I have had a letter from the court. I think I'm allowed to share it because it's just a letter telling me about the fees. So it's nothing to do with the people. So, so remember that I told you at the beginning that we've got 3 sets of fees, okay? We've got the $1,100. Well done, at least you're, yes, Betty says, at least you're challenging them. What is, I'll explain in a minute what is the goal when I tell you this. But so we've got the 1,100, which was sending us from the High Court to the Appeal Court application. That's the first one. Next one is the 7,000 security fee, that if we lose the case, or even if we win the case like they did to Fitzgerald, he won the case and they made him pay anyway. And we're disputing that. We're saying that the judge, that you should not have been allowed to do that even back in 1976. So the whole Fitzgerald case has been brought back to the modern day, and they're sitting in the court as we speak, fighting over whether Fitzgerald should have had to pay since he won his case, and he shouldn't. I'm saying under the King that we have the right to petition the King, and all commitments are illegal, and they made him pay even though he won his case. And I'm saying bring that case right back to the court 47 years later, because I believe the court was wrong, and I'm disputing the judgment of the court, which is 47 years old. So they're going to be having a right little chat down at the courts back at the Fitzgerald case, and it ain't even got nothing to do with my case. They're back to fighting Fitzgerald. Now, if they decide that the court was wrong to charge Fitzgerald that money, I don't know, maybe his family, if he's still alive, he could take them back, and he's going to get 47 years worth of money back, plus interest. Or if they decide that they were right, that's going to be difficult as well, because they're going to have to go up against, then they're going to have to go up against the 1688 Bill of Rights that says that we have the right to petition the King, and all commitments are illegal. In that case, they're going to have to make a very careful judgment against the King. So they're stuck between a rock and the hard place, and it's got nothing to do with me at all. So this is an exciting time. Never mind Kate Floss, we're on Fitzgerald again. So whatever is decided, this is all going to be going to England. I imagine that England's going to be having a bit of a chat about this as well at the moment, because they've been trying to make us all pay. Now, so in the meantime, I got a letter back from JC McGrath, the one that said to me that you've lost your waiver and you have to pay. So I've had this letter back, so I'll read it out for you, but the ones, I can't post this to you if you're on YouTube, but I can read it for you. So, but I can post it on my Zoomie. So it says here, dear Ms. Sextus, they're very nice to me now. Your application for, have a listen, your application for review of my decision declining the waive of the filing fee, which is only one fee, has been processed and given to the judge. So the judge on that particular issue still hasn't decided. So we still don't know what he's going to decide. But he says, I note that you mentioned security costs. This is the $7,000 in your review application. If you wish to apply for security costs to be dispensed with, reduced, or deferred, a separate application should be filed and served pursuant to R35(6) of the Court of Appeal Civil Rules. Now, Maxine is my Morpheus, and so Maxine's my Morpheus, and I usually just flick those over her way. I don't know if she's up for it or not, but if she's up for it, I'll be having Maxine flick over to that Court of Appeal rule. We won't talk about it today, but it is section R35 in bracket 6 of the Court of Appeal Civil Rules 2005, which I've posted up there for you to look at. So we'll have to go and look at what that is. But what the important thing is that he says, these are all the stumbling blocks that you're going to have, but it says that we can apply to either have it, we can apply to have it reduced, which is quite good. We can apply to have it deferred, which is what I'm going to apply for, or we can apply for a separate application, which should be filed and served pursuant. So we can apply for we can apply for a defer of it while we wait for the judgment on the 1,100, or we can apply for a whole new separate application, or we can apply to have it reduced. And so I'll have to talk with my Oreo team about that, and we'll all decide together what it is that we're going to do with that one. What did Brent say? That's so right. I can't see in there what are your comments. So but anyway, so so we'll have discussions about which one we're going to do. Follow through. Right, so Betty says, all right, I'll talk to Betty in a minute. So that's going to be very exciting about what we're going to do next, because we had the last day, the last day for the application to file about the $7,000 security fee. The last day is tomorrow, I think. So I have since sent him a quick notice, and I think it's the last day is tomorrow. Hang on, I better check. So the last, now don't worry if you missed your extension of time, because under the Declaratory Judgment Act, it says that if you haven't filed something in time, it does not stop your case from going through. So you just have to let them know. Oh, thank you, Maxine has sent me the link. But the last day was the 19th of July. So it's the 19th tomorrow. So the last day to make my application. However, I have asked him for a couple of days. I've asked them, you can always send them a note. They're so good down at that appeals court, not like the High Court. They respect your constitutional laws and your indubitable right, because they understand all of that. And so they're very, very, very extremely helpful to me. I've got assistants everywhere I turn. I have an assistant that helps me. I'm not allowed to ask them about what to do about my case, but any questions about what I need to file or how I need to file something, I just ask them and they just send it to me immediately. Usually, sometimes they send it to me within minutes, and they send it to me, and then I know what to do. And then I've got Maxine, I've got the Oreo team helping me, and we've gone over time. So we're going to have to quickly, I've asked him for a couple of extra days, because the last day to file for that deferment of the $7,000 security fee, the last day is tomorrow. Now, remember, while we're battling over this money, even if we lose about all of the money, we can drop the case immediately. And the important thing is that we've got them talking about the 1688 down at the appeals court, and they're not even talking about me, they're talking about Fitzgerald Muldoon. And so that's going to cause a whole lot of flurry down there at the moment, all deciding what they're going to do about that case. And so if at some point I decide I can just dump the case, and not, if I lose on all of the monetary thing, I can dump the case, but I will still have answers about my 1688 because of the things that I put in. So now I'll just talk here about the people that I've got. I can share screen. I've got this. Now I'll talk to the people that have been talking to me. Kia ora, Kate. Thank you for sharing your knowledge and understanding. That's from the Truth Seeker New Zealand. Thank you very much, Truth Seeker, for acknowledging all our hard work. And don't forget the Oreo team, who all contribute immensely. Oftentimes you don't see us all together, but we're all sitting up well into the night, into the early hours of the morning, and it's the whole team, but you can't see them. Betty says, well done, at least you're challenging them. Yeah, because we weren't supposed to get in the court, but we managed to get our little way in there. I really don't know how, but God was with us on that day, and we got in there. So now she's saying follow through with the Brett Style-Dard case, and you have rocked them up, laugh out loud. So can we just, I'm just going to Google that. It's called the Brett Style, F-R-E-T-O, S-T-E-I-L-D-A-R-D. I don't know what country it's from. It's a case study. Come up. Oh, goodness me, you little beauty, sending me more information. So this is called, so there's not really, so I can go to view all. Oh, it was an environmental case. Oh, Fitzgerald, yes, yeah. Oh, okay. Fitzgerald, oh, okay. That's Fitzgerald, oh, Fitzgerald, yeah, my accent got my news. She's saying Fitzgerald case. Yes, it's the Fitzgerald case that's going to, but there is actually a Fitzgerald case as well, a semantic scholar. Oh, wow, there is actually a word. Yeah, but he couldn't spell it. But funnily enough, that one that you put there, Betty, the Brett Style-Dard, there is actually a case. So I don't know what it's about, but I might go and look at it later because it's got lots of stuff and it looks very, it's not a court case, I don't think. All right, so anyway, where is everybody? So I've got everything start. And we've got the Fitzgerald case, right? So we're going to be finishing up this video, And if has anybody got any questions, she can't spell. Right, open up the floor for anybody with questions on the floor and just come in and say hi. What is it now?
I see on your letter, Kate, that you have to serve the respondents again with what?
Oh, yes, the security fee. He's saying that anything in regards, mine was the application to appeal, which is what I was disputing. But the security fee is the money that if you lose the case, that money goes to the respondents and their solicitors. But I'm also saying in that case, since they're a government official and they wrote the law that caused me to be fearful, that I shouldn't even have to pay a security fee. And I'm saying that it shouldn't matter whether I win or lose. Even if I lose, the fact of the matter is that their lawmaking and there has made me very fearful. And that's what has caused me. The ultimate cause of why I went to the court is because hundreds of people are saying to me that they are fearful. And I am myself fearful. And I'm not even in New Zealand. But I've got people messaging me every day about being fearful. And so I believe that the Parliament has a duty to come to the court and answer in a quiet, safe environment and answer to the people, because we've had protests where people have been beaten up. We've had people beaten up in their homes. We've had them changing laws every week. We've had them saying you're not allowed to enter your own country. We've had them saying you're not allowed to leave your country. How scary is that, to not be allowed to leave a country? That is scary, man. That's scary, to tell someone that they're not allowed to leave a country. When you're stuck
Had them harassing people too.
they're harassing people, they're beating
I'm
people.
sick of it.
And they're even telling you that you cannot even leave your country to get away from these people that are beating you up. Now that's scary. And they have a duty. I'm saying to the courts, you've got to open up the courts to the people who are fearful and let them come in to a quiet, peaceful environment and ask their questions of law. And I don't care if you can't be bothered. That's too bad if you can't be bothered. You're paid $400,000 a year to be bothered from our money. Now you be bothered and you get your ass in there. You get your
Tush.
your bottom, your bottom. You get your bottom in there and answer the people their questions that they're fearful about. Don't you think, everybody? Yes.
Certainly agree.
So,
Agree.
but anything to do with that security fee, we have to send that to the respondents and let them know that we're asking for a deferment, or we're asking them to just wait until we get the outcome of the first Fitzgerald case. We're waiting for that, so we can ask for a deferment. So that's most likely what we're going to do. Yes. Okay. So any more next? So we've got Betty. Betty has said. Betty has said to us. Oh wait, I'll just say
My
Betty.
hand was up first.
Okay. Brent.
So the other night I got pulled up again by the cops, and a cop who I'd never seen before in my life knew exactly who I was and started questioning me about my firearms license and all that, and they had me on the side of the road for about 10 minutes looking around my car and asking me about my firearms license and whether it had been revoked or not. And I'd never seen him before in my life. He knew exactly who I was.
Did you have the 1688 with you? Brent?
No,
Did he ask
No.
you for ID? Did he ask for
no,
ID?
yes, they asked me for my driver's license.
Yeah. And then and what makes you think that he knew exactly who you were?
Because he was asking me about whether my firearms license had been revoked.
Oh, because how did he know that you had a firearms?
Exactly.
No. Of course, they should have known that I had a firearms license, but yeah, he shouldn't have known, you know. But obviously, it's common knowledge within the police that the firearms people were trying to get hold of me for so long, and he wasn't sure whether my because of all that hassle. You remember, I'd been avoiding them for months. Well, obviously, that had gone around the station, and this guy knew who I was, and said, "Has your firearms license been revoked or not?" He asked me.
Right. And so you told him that it hasn't been, right?
Yeah, and apparently because they pulled me over because I had no front license plate number, and they told me that the plate had been used in a drive-off petrol bloody thing.
Whatever.
Yeah, that's what I reckon.
And
What
did
is
it
it?
have a plate or not? But did it have a plate or not?
No,
Right. So
yeah, it's possible, but the thing
he
is,
let
he
you
knew
go.
exactly who I was. He shouldn't
Did
have
he let
known
you go
exactly.
to
Yeah.
He
Yeah.
shouldn't have, like he should have seen that I had a full driver's license and the car I was driving was owned by me. But he shouldn't have questioned me about my firearms license
Exactly.
because he shouldn't have known about my firearms license. You know what I mean?
Yeah, you
He
should
pulled
have
me
just
up
pulled,
for it was a
just pulled you
driving
up for the
incident.
plate.
It's
It was a
certainly a scary time that you have to have all of your T's crossed and all of your I's
Eyes
dotted.
dotted.
At this
Yeah.
point in time, we do know that a lot of people, and I think the best thing is you were with them for 10 minutes, but what I really want to say about this is that some of the common law people have been pulled up and they're keeping the police busy for an hour, sometimes 2 hours, saying, I don't want to show you my ID, I don't recognize your jurisdiction.
No,
And
I
they're
didn't
there
do
for
that.
but he didn't do any of that. I'm just saying that what he did is he just said, look, here's my license. And the cop asked him a few questions and he gave back the correct answers to the questions. And he was there for 10 minutes and it
Yeah.
probably would have been very scary. But then he was on his way because he cooperated. He
Yeah.
cooperated completely and the police checked him out and the police said, okay, you can go now. You're all gonna, in this very, very scary time, even though you think, I'm sure that you think that you don't have to talk to the police and everything, but just for your own safety and with all that's going on, if you do that, it's not going to hurt you. If they say to you, what's your name? And you say to them, my name is Kate Floss, and they say, how old are you? And you say, I'm 25 years old or whatever. It's not going to hurt you.
Wish.
I do. Wow. Well, come on now. I'm not looking bad, Sharon. And so, but I mean, if you behave like Brent did behave, even though it is annoying to you as a person,
It'll make it easier.
in these very dangerous times,
Yeah.
the police have been beaten up and stuff too. So they've had a hard. Some of them are bad, some of them are good. So there's a lot. Everybody's scared at the moment. Everybody is in terrible fear. And if you can just make it a bit easier by giving your name and stuff like that, you'll be on your way. Well done, Brent. But it is scary. So, so can I go to Bessie now?
Yeah.
Or do you want to say something, Brent? No, he's done.
I'm good.
So, all right, Betty. So Betty says Google case is similar to the Fitzgerald case. There is only one case. There's only been one in 47 years. In 47 years, the 1688 has never been used in New Zealand. And it's going to be used for the first time in 47 years. And here is the only case. So that's where we use it. But there should, in fact, be dozens upon dozens of these cases, but they've been blocking us in the court with the corporation, the process of the court, and with the fees. That's how they've been blocking us. And then that's what we want to do. We want to clear these barriers for you. And then once we clear all these barriers for you, we want to show you how you can go and make a case for yourself and you can do it all on your own and you won't need me. And that'll be the end of you see Miss Kate, and I'm going back to my comedy. So that's what I want to do, comedy. So
Can I just say something?
yes, Maxine.
The fact that you have to answer, the fact that she sent through that letter, talking about the other fees is an insult, considering that your whole reply about that $1,100 or that $1,100 technically should negate any other fees, because you've set out in legislation all the and with all the documents to say that we should not be paying going to petition. So I would just I'd keep your same letter and shove in the those rules and send it right back.
Yeah, because by doing a deferment, is that almost saying that
Yeah, I can
yes,
just
you're going to
defer.
pay them, and you're just deferring that payment? You're actually acknowledging that they're payment.
No. I can defer until the outcome of this one. Not defer, and then when I get the outcome of this one, then I can go back again. If I lose it, then I can go back again and I can ask for a reduction.
Yeah.
So, or I
Shouldn't
can
be a
also
reduction.
ask,
We've got to beat this. We've got to keep gnashing on about the 16. You know, it's written in law. They shouldn't be asking for those fees.
no, they shouldn't, but they have been, because of the 1990 Bill of Rights and the human rights, where they've been getting those cases paid and paid and paid and paid and paid.
Yeah, but we're up there, they're down there, so we're playing.
Yes, I
we're
know.
not
All
playing in
about
their
the
field.
money. All
Yeah,
about the money.
No, well, listen, there has never been a case in 47 years. Ours is the
True.
first case in 47 years. And in the last case, I'm challenging them because I'm saying to them that they should never have charged Fitzgerald.
That's
And
right.
so that's what I'm saying. They never should have charged Fitzgerald. And and so, but you have to go, there's still a process that you have to go. It's like what happened with Brent. When they go to the common law people and they say, what's your name, how old are you, and where do you live? And the common law people spend 2 hours arguing with them. Whereas Brent went through the process, they said, what's your name, how's your gun license, is it up to date, why haven't you got this plate and everything? And they checked it all out, and he was gone in 10 minutes because he followed the process. And this is the same down at the court. You can go down there and stamp your feet all you like, that you don't have to pay, but they've given you a process to follow. And if you do what they tell you to do, then you're going to get better. So he's sent me the letter. He said in the first one is different, because in this one we have to let them know what we're doing. The other one we don't, but this is in regards to their money that they are expecting to get. So we need to inform them, but we don't need to tell them everything. We only need to inform them that we're waiting for the outcome of the decision on the first fee, and we would like to defer any what's the word?
Decision on the payments.
Yeah. We would like to defer any decision on this security money until we get the outcome from the judge of the first one. And so that's just a short note that I can type that up tomorrow. I'll send it off to him. I'll send it off to the Crown Council. Crown Council knows that we're still interested. He knows we're still interested, and everyone just knows what we're doing. So he didn't demand the payment. He said, what do you want to do? Yeah, so you've got to follow them. The next one, but Maxine is correct. Maxine is extremely correct.
Yes, I think so.
If we win and we don't have to pay, then we can use exactly that for this as well.
Yeah.
And we'll go through that process as well. But if we lose, we can even appeal that to the Supreme Court.
Yeah.
Well, you might, if we win, you might want to offer courses to their registrars about how, I mean, you and I, we could offer courses to the registrar of how, how they...
How unintelligible they are.
No, because obviously,
They are though.
Vexatious.
Vexatious. Sorry.
Vexatious.
They've been vexatious to me.
Yes.
I believe they're being vexatious to me. Right from the High Court, they were vexatious to me.
I think they'll be regretting that now.
Because I found that Dyson case from England, and it
Wow.
says that I should have the right to be heard because I'm only asking for a declaration. I'm not putting anyone in prison. I have the right to be heard, and they didn't consider my right at all. And so, yes, they have been vexation. So that's right. We should, Maxine, we should call them in and we'll charge them $300. We'll charge them we'll charge them $500.
We'll charge them $1,100 a year.
Dollars, yep.
Yeah.
It's like you've got all those registrars that didn't know what they were doing in the High Court.
Yeah.
You know, I mean, far out, we're going to be rich.
We're going to be rich. They'll all have to come and see us and ask us about the Oreo, Kate Floss and the Oreo team, what they're supposed to do in this 1688. Now, next one says from Betty. This one's from, Betty says there's meant to be another lockdown after the school holidays, and they are rising the fear now with cases. Yes, and they're changing laws in regards to all of that. Now, I'm not going to go into too much of that because we don't have guarantees on what they are, but all I'm going to say is that, yes, many people are fearful. And if we got in this group, we've got 1, 2, 3, 4, 5, 6 people. I'm going to ask each one of you, have you been fearful in this last 6 months of the government and the laws that they're making? First one I'm going to ask, Brent, fearful or not?
Absolutely.
Maxine, fearful or not?
Yeah, back in December, yes.
Very fearful. She lost her job, by the way. She lost her job and she was scared she was going to lose her house. Yeah.
I'm just angry
Sharon,
now.
now she's angry. Sharon, fearful or not?
Yes, especially for my grandkids.
Very fearful for her grandkids. That's exactly right. And for their future. Jody, what are you fearful about?
I'm fearful for my family, fearful, very,
Very fearful. Diane, what are you fearful for?
Very fearful. I actually wanted to leave the country. For the safety, I wanted to sell up everything and just get the hell out and take all my kids with me. That's how fearful I was. I mean, my husband's buried here, and I would never think of leaving my home country. But that's how fearful I was.
Yeah.
Can you remember when I first met you, Diane?
Yeah.
And what did you say to me about you thought about leaving, and then what? And then after that, what also happened in your fears? Do you remember? Because I remember what you said to me.
There was nowhere to go.
Yeah.
Nowhere to hide.
nowhere to hide.
Nowhere to go. I couldn't go back to Ireland where my ancestors had come from. I have ancestors from England, Ireland, and Scotland, but that is gone. I don't have that. I can't go back to any of those places. So, yeah.
The thing that Diane realised is that in our Commonwealth, that the only places that she had as options to go back to were our 5 Commonwealth countries. And she realised that it didn't matter which one she went to, they were all going through the same thing, and she was going to be fearful no matter which one. So she got stuck in New Zealand. And I'm fearful because I'm outside of New Zealand, and I had desperately wanted to go home. I haven't been back to New Zealand, home to New Zealand for almost 10 years now, I think. But it was my plan, our lifelong dream, that my husband and I would go back to New Zealand immediately that he retired, and we were all ready to go. And my husband's quite old and he's got diabetes, but he really wants to come back to New Zealand. He's been there twice, and we are very fearful that we're not going to get back to New Zealand before we die, especially him because he's diabetic. And so we are fearful about not being able to enter my country, and so I'm fearful. Sarah Gold says, Massive high five to you all. Sending much love to all the Oreo team and protection for you all. And she's from the South Island, New Zealand.
Thank you.
South Island, New Zealand. And then we've got Betty Bro says, apply for legal aid. We didn't want to do that because we could not get a solicitor that was prepared to take our case to the court. And
We tried.
Yeah.
tried.
Yeah.
But our goal is to
To prove a
show
point.
you
Yeah.
as a common law person or as a common law group that you can go to the court by yourself. You don't need them because
The
they're
th-
going to block you every step of the way.
The thing is, as we've all spoken before, is that these lawyers, they're not trained in that law anymore. So nobody knows anything about these laws except Kate.
Yeah.
She's the only one who knows anything about these laws.
Yeah.
You know, then
Even the
lawyers,
court struggled.
they're all taught the new school laws. They don't know the
They don't.
our real true history laws, our natural laws.
Our
Well, they
ancient
do know
laws.
them. They've been hiding them and they've been preventing us from going to the court, using them incorrectly, telling us that we're not allowed to go to the court. And all I wanted to set out to prove was that we are allowed to go to the court. And that's what I'm determined to prove here. And then we want you to all be able to do it. But if we really, we did try actually to get some legal aid through the Otago Law Society and various law societies. And they all said, we only deal in community law, subordinate law, human rights. We don't deal in constitutional law. So we couldn't get them. Betty also says, that is the only case exposed. What about the cases that are hidden? Oh,
Yeah.
she said, there are heaps. What I reckon, Betty, is that there are heaps and heaps and heaps of people that have tried to get them into the court and they've been rejected before they got through the court and wrongly rejected. Wrongly, and how many of them have not been reported? But I believe there's many, yes.
Just a quick note. Tell them about the missing documents with the Fitzgerald case.
All the documents, apparently, in regards to the Fitzgerald case, all the documents are missing and they don't have them. They only have the court ruling and that is it. They don't have any of the applications, nothing. And we're very suspicious about that because anything to do with the Prime Minister is historical and it would have been all kept in England and they document that stuff religiously. So we're very suspicious about why the documents of Fitzgerald are not being kept. And yes, Betty says
Buried.
just like yours. Yeah, buried. They're burying them. So that's why I'm doing all this case up in the public for those wishing to follow it, is because we want our case, we don't want them hiding anything. They're not going to be able to hide it because I'm posting it. I've got my Oreo team. Every single one of them knows every single document. I send the documents to them and it's all being kept on record. And we might write a book one day, or even if we don't, it's all going to be on record and we can retrieve it at any time. We've got it on multiple places. I've got it on computer, everywhere.
I was thinking about this earlier on, about half an hour ago. I think you need to get Zen to download everything you've got onto a hard drive for you so that it's not just on your computer.
Well, it isn't. I've got it. I'm not that silly. I've got it all.
I just wanted to make sure.
It's on Facebook. I can do that.
Even though when you're going to get hacked.
Yeah, no, it's on Facebook. It's on YouTube. And Maxine keeps everything as well. She's got records of it all. Sharon's got it all. Jodie's got it all. Jodie is the record keeper, although I've been a bit late to send her, but she's the record keeper.
Yeah.
But Maxine keeps on to it.
Yeah, and Maxine lives in Switzerland.
Maxine lives in Switzerland. Maxine's in Switzerland.
And I'm
Yeah,
in
well,
Mexico.
Just so long as just so long as we got backups of the documents.
Sorry, I did that. You sorry.
Anya. I think what Brent was saying was to put it on like a hard drive wallet sort of thing, hard drive thing.
Yeah, to get it offline.
Get it offline because everything goes belly up. What's that? Hard drive. Oh, good
Yeah, it is
girl.
actually in the courts. It is actually in the courts.
Yeah,
And,
and actually, it's with the Otago group too, isn't it?
the New Zealand Law Society is keeping tabs on it.
Yeah.
And
Yes.
so it's on the New Zealand Law Society, so they're keeping tabs on it down at the Otago Law Society. You can bet there's a lot of people keeping tabs on my case. But now that we've
Even that guy, even that guy Hokey,
Mr. Fishy.
Yeah, Hokey coming. He was the one. Hokey gave us the best advice, and he said to me, he said, "You know what, Kate? What got you into the court was the 1688." And he said, if you stick with that, that's what's going to keep you in the court. Yeah. And so when he said that to me, when I wrote this appeal, I didn't use any other law, nothing.
Nothing.
I only used that 1688. And if there wasn't something in there for me to retrieve, I wasn't going to use it. And I only used that. The Hokey taught me that. He taught me a huge lesson. And so he said, if that got you in there, that's what. And we're thinking that the reason many of the common law people have not been able to get in is because they've been attaching
other laws,
human rights, or that they've been attaching subordinate laws to it. The minute you attach a subordinate law to it, it goes down into the lower civil court or the administrative court. It doesn't ascend to the heavenly realm. We're ascended to the heavenly realm. So I think that's one of the reasons that we want to teach everybody. Don't attach. If you can find something in that 1688 Will and Mary and the Declaratory Judgment Act, both of those together, you must not attach anything else to it. And I have met several people and I've seen several court cases which would have been beautiful to use the 1688. But because the lawyers don't get paid money in it, and the United Nations gets paid and LexisNexis gets paid hundreds of thousands of dollars for you to use human rights in 1990, the lawyers are deliberately not letting you go down that path.
Yeah.
And so even though they use that, they are attaching all these parasitic laws, and that's what's getting your cases thrown out. And that's what's preventing you. That's why I don't want to use lawyers. That's exactly why I don't want to use them.
And that's why they're using an ex-criminal too. An ex-criminal that puts all these cases through, hence Taylor.
Yeah, that's why they're doing it. So we won't go there, but yes, that's exactly right. But Taylor's case was sent to England using the 1990 with the Declaratory Judgment Act. But ours is pure 1688 Will and Mary together with Edward VII Declaratory Judgment Act. Ours is pure, and so hopefully that'll get sent to England. And the whole thing with Fitzgerald is going to be burst wide open again and brought right to the forefront again. And so hopefully they won't lose it all this time. We'll have to make sure that they don't lose it all this time, like they did last time.
Or hopefully they'll bring the case back out into the open with all the documents.
Yeah, they just somehow found the
all of a sudden. Here it is.
Oh, here it is.
Hopefully the family members might have kept a copy of that judgment.
I hope so.
Yes.
Well, I'll bet you anything, if they need it against me, they're going to find it. Depends if they can use it against me or not. If they could use it against me, they're going to find it. So Fitzgerald is going to be coming out. But Betty says to me, the enemy is the system, the lies and the deceit. And that is exactly right. The lies and the deceit have kept all the common law people out of the courts for decades upon decades. And I believe that there are hundreds of cases that have been turned away that should never have been turned away. And I do believe that. I believe we've got to break this wide open for all of our Commonwealth countries. England, we're going to finish up here and we'll come on the Zoom for discussions, but I'm off with the YouTube. I'm going to say England, Scotland, Ireland, Wales, Australia and New Zealand, our countries, we're not under American law. We're under the common law of the 1688 Will and Mary and the Edwardian, Edward VII declaratory judgments from the Edward, which I think that'll be a constitutional law. I have to hunt it up. I've only found the act, but you've actually got to find the actual one. And I think it came out in 1808. Thought I heard one of the people in that Moai Crown talking about it coming out in 1808.
That's right. Yes.
I'm going to have a wee look. Right, see you later to the YouTube and finish up recording. Smile for the camera. All right, smile for the camera. I'm going to turn off the recording, so wait till I get my smile down. Should I tilt my head or not?
Vogue.